Adv. Poulekar has been practicing law now for more than 25 years. And if you are important enough, you might have got into one of these cases. What I mean is, if he was maybe running with private young, then he would have landed up in his lap. If you are dealing with the Scarlet murder case, you would have landed up in his office. You were interested in the arrest of that Israeli Guru, drug fellow, the head of the students. If you were interested in that Curly's illness and that death of that woman, Bogat, you would have landed up in this place. So you have to be important enough, otherwise you don't land up there. That's correct. How notorious enough. Anyway, that's the legal part of it, but most people do not know that he is an avid footballer. And we always like to have people who speak. Last time we had an advocate who was a weightlifter. And he was in the finalist of the Goa weightlifting championship. But he also came and delivered very good lecture on administrative work. But Adv. Poulekar has been a member of the Goa Football Association and of the ethics committee which looks into match fixing, which is inevitable in Goa. Then he holds a B license from the Asian Football Federation. He has completed a C license course in football with affiliation with FIFA. He has a level 1 license in football from the World Coaches Organization from Holland. And level 1 license in football Premier Skills from the United Kingdom. So be careful, you may get kicked out. There is, of course, also the other aspect of these people who are a little bit freaked out of football. He has training, he's part of the training system for all youngsters who become footballers up to the age of 14. So all of you are disqualified. So that's free. So don't try and get in there because it's free, because only for those below 14. So too much of trying to be funny. I will hand over the thing to him. You have got his background notes. He will speak more or less on the criminal law system. I think that probably most of you are not got involved yet in the criminal court, but this is just in sort of a precautionary principle that you don't get involved at some stage and that you will not be involved. Adv. Poulekar will know his class.
Mr. Klam, about this his wife is not here. His team is here. First of all, thank you very much for inviting me. This is the second time I'm coming for this. For second time, what is this season? Second season of this stuff. But before starting this lecture, I would like to mention something. What happened that day, my partner's birthday was there, Caroline, and we were there together. Star was there, his wife was there, Nama, and my son was there. So my son told me, he's in 10th standard. He told me that I want to meet Mr. Klam. I said, okay, all right. So I introduced, and then I heard this conversation. My son told me that I am quite a big fan of yours. I said, wow, that's not bad. Like, okay. And then for that birthday, it was some disco type of this. He sat with them and so they were communicating almost for half an hour, 45 minutes. And last Sunday, he told me that we were supposed to, I and Adv. Keen were supposed to visit Bori Beach. You must have heard now that a new Bori Beach is coming up. So he said, I also want to come to see. So we went there to the Bori Beach. And if you know this, what is happening there, like the new Bori Bridge, after going there, we realized, even I thought first, Bori Bridge means a new Bori Bridge is coming next to Bori Bridge only. Like how Pension they have done. It's not like that. If you know the road which is coming from Verna Industrial Estate, the Bori Bridge, new Bori Bridge starts there. It passes through that Lotulium village, above that mangroves and the river on the other side. So it is almost around 7 kilometers, I think so, roughly. That kind of bridge coming up, which is going to destroy entire ecology of Lotulium village, because we were there with many farmers association there, doing a site inspection, and they told us in that Lotulium village itself, in that particular field area, it's a big area, vast area, that a particular type of rice is grown, which is only grown there and nowhere in the world, which is very healthy. And when Corona time, only they had that rice. So that is going to get destroyed, most probably, the whole ecology there. And the Foundation is working on it. But what impressed me is that I don't know what talk they had with my son, but then he said that I want to come there. You know, it was very impressive for me, because I feel Goa Foundation, by doing whatever work they are doing, are influencing the young minds, and that is more important. I see young girls, home is with them, so perhaps I hope and pray that more young kids come, join you, and start working to save our Goa. So with this, we will go to today's topic. Today's topic is basically what we are dealing with is hierarchy of the courts, Indian courts, and the new laws. That is, I will use the short forms only. PNSS, which replaces the old criminal code, then PNS, old IPC, then BSA, that is old evidence. So all these laws are repealed, and we are with the new law. I remember when I became a lawyer, this was way back in 99 actually, but I joined Peter. My boss was Advocate P. D'Souza. He was specialized in drug cases, and when I joined him, I studied the whole law, in first year, like 2001, and all of a sudden, 2002, entire law changes. So I went and asked what is this? I studied everything now, and then I will study the next law again. He said, what is your problem? We should be happy that now you and me are on the same page. So all the lawyers, whether it's old or new, they have to study the same law. So that's it. Whether we like it, we don't like it, the laws are here to stay. And as people, you have to deal with that law and use that law for whatever purpose. So we can't go back. So what happens to the old law? Now, whether CRPC, Evidence Act, what happens to the cases which are pending before the courts? What happens to the cases where some judgment will be passed in near future? What law and which law will be used? Whether it's a new laws to be used, old laws to be used for that? All these answers are given in one particular provision, that is 531. I believe that 531 of Bharatiya Nagrik Suraksha Sanhita, that is BNSS. Now what it says that pending application, pending investigation, pending trial, pending inquiry, if all these are pending, then only old laws will be applicable, although the cases may go on for another 5 years, 10 years, 20 years. You know how it is in India. We don't know. So we will run a two parallel system. For the old cases, the old laws will be applicable. For the new cases which come from July 1st of 2024, the new laws will be applicable. But there could be a situation, let's say, for example, the sexual assault case or rape case, which has happened, perhaps offense took place somewhere in January of 2024. The laws have come now. So, and no complaint is pending, nothing is pending, no application, no appeal, no investigation. But all of a sudden, a lady comes forward now in December 2014 and said, no, in January I was raped by someone. She goes to the police station, she files a complaint. The question arises under what law a complaint has to be registered. Whether it's a new law, old law. This answer still not there. So there is complications are there in the interpretation. We have to wait for the Supreme Court till the matters go to Supreme Court for the interpretation purpose, and eventually we'll get some answers. So there is some vague area in 531. But my opinion, my humble opinion, is that if the offence was there in January, then it will be the old law itself. Old IPC will be used, not the new BNS. But the procedure, since the old laws are repealed, the procedure which is followed for conducting the investigation and trial will be from BNSS. So this will be this kind of situation will arise. But we will deal more with very basics which is required in this law. That is investigation, then how the trials will go through, and arrest and remand. This part, because I have been told that Advocate Caroline has covered that bail topic extensively. So I will not deal with that topic. So first part for starting of any criminal justice system is lodging a complaint before police. Now that part, once you lodge a complaint, the police has to start investigation. Now earlier, as per the old CRPC, what used to happen was the person had to go to police station, write a complaint, and give a complaint to the police. And then they used to start the investigation. But in the new BNSS now, under section 173, there are many changes, and this will be very effective, I feel, and complicated also. They said that FIR can be filed by way of sending a SMS. This is new. SMS, email. So by using an electronic mode, you can file a FIR. Question that arises here is, if a person sees some offence on the road and he sends a SMS to police, something like that. This is a cognizable offence, some assault has taken place, or even video is sent to police. Police will take and police will keep it as per the law. Police cannot register the FIR directly. They have to register in that book, a particular book, and they have to tell the person, whoever has sent that SMS, please come within 3 days and sign. Then only the FIR be registered. Now this is totally against the criminal justice system. But what happens actually when offence takes place? Immediately the investigation has to start. Because if you delay, then you lose the time for investigation or collection of evidence. For example, I send a murder, I see a body lying on the road, I send a SMS to police. Are police going to wait for 3 days to recover that body till I come and sign? And what happens if I never come? Are police not going to investigate? These are all grey areas which will come for interpretation before various courts as a time passes. They have introduced in 173 another aspect. These are all new aspects they have introduced. Something called zero FIR. Let's take an Asgaon case. Asgaon property, the famous case where the bungalow was demolished by someone. What happens is that demolition takes place, I think so, while when somebody goes to the police station, they don't register the FIR, so they come back on the spot. Something that is happening. Now, what choice the lady has? Suppose you go to the police station, the police does not register. Now, perhaps in that kind of if the new law was there, then instead of going to Anjuna police station, she could have gone to even a Mapsa police station. Because now the law says, Venice says that you can register something called zero FIR. Now, this concept was not there earlier, something called zero FIR. But Supreme Court has said in many judgments, yes, this can be done. So this is a new concept of the FIR. Then once the FIR is filed, then the actual investigation starts. Earlier what is to happen in the investigation? Let's say this Aslam case itself. They register the FIR, they have to call all the witnesses for recording a statement. Once witnesses come before the police, they record their statement, but they need not sign that statement. The new law says that now you can video record the entire statement. Now imagine the case in Asgam. You know what has happened perhaps in this. Like first there was videos of the lady saying that people came and demolished. Then there was a reverse video saying no, we are all right, it's fine. In that kind of case, wherein if the videography is done of the witnesses, can these witnesses go hostile in the court? But the whole system works on a statement which is not signed by witnesses. But now the judges may have a video. So the appreciation of evidence in the court may be slightly different based on this video. But audio-video recording is in a big way bought in by them. Then there is another provision which is very deadly, I feel. And let's say it was there at that point of time, last down. It is called 173(4). That 170 section divided into 4, which gives power to the officer in charge not to register the FIR. Earlier law was that if any cognizable offence is committed, like a serious cognizable offence, a serious offence, chapu marlo, guli marli banache, then you register the FIR straight. You have no choice. Officers are not given choice. Now the officers have choice. The officers can take a complaint and say that no, I am going to conduct an inquiry. If that offence which they are claiming is up to 7 years, then 14 days are given for them to the inquiry. In inquiry, they have to come up with a conclusion that yes, there is a prima facie case, and therefore I am registering the FIR. Or if there is no prima facie case, I am not registering the FIR. Imagine now that Asgam case itself, if this choice was there for police, that complaint is filed, they have 14 days to register FIR. Everything perhaps will be settled within that 14 days. No case, no FIR. So we are looking at this kind of system in future. So this is with respect to 173. Then comes another picture which we have added, which is I feel very progressive in nature, that I am very influenced by groups like by Netflix and Amazon. They say that you have to take forensic expert in the field now. So if there is a murder, or let's say the Asgam case itself, a forensic expert has to go on the spot and check what has happened. If, for example, in this case, Asgam case, if forensic expert goes on the spot, what perhaps he will mostly do? He will see if there is any CCTV footages around the area to show or to see who are the people who have come, who are the people who are demolishing that house, and they have to recover that part. So this is the progressive step. But we have seen earlier cases, some cases where police have gone on the spot and they have attached cameras. Now there is no footage in cameras, and they have attached and got in the court this. So when this opened the court, there was no footage. So therefore, this appointing an expert going on a field to conduct a forensic or collect the forensic evidence is very important, because perhaps our police who are earlier there are not so qualified to collect the forensic evidence on the spot. So in that case which I was saying, that footage was not there, so the accused was acquitted because they had not attached DVR, they only attached the cameras. Perhaps the person who attached the camera was not knowing that camera does not have any recording. So it is that way. So it is simple as that. Therefore, this provision is a welcome and a progressive step with respect to that's the 185. Now, another important part in the this is 185 section, which they said now you have to conduct a panchana. Like for example, again, this Asgama, how it's said, they have gone on the spot. They are saying what is demolished, what is that excavator is there, all that. So they have to conduct a panchana. But earlier panchana means two respectable panchas are called and they used to like, we went on the spot and we saw this place, the blood was fallen, your body was there, and then it's complete a panchana. Now they have to do a video recording of entire panchana. So whatever police are doing on the spot, they have to do an entire video recording of the panchana, which will be useful for the prosecution. But how they will do, whether people who are there are really qualified to do this kind of work. Especially for example, let's take a drug case for example. In drug case, what happens, always claim is made that information is received and that they have gone on a spot, the accused comes there on a spot, they have give an offer to the accused to take a search of the raiding party members, and they tell the accused, if you want, I will take you to the magistrate to take a search. And the accused declines the offer. Then they search the accused, they find the drug. Now, by going by 185 section, you have to record this in the panchana, in the video. So how that will happen practically, I do not know, because like these Nigerians, and they are very aggressive. Like I remember an old case where PI was at then, and one friend next door was arrested. They had gone into his house to conduct a raid, and Uday Naik was a little dramatic fellow, the comedy man, I would say. He told us, अरे तू अच्छा ना तुझं तो 21 कोस असा तो आम्ही दार उघडल्याने गेले तू आम्ही कोयता किने तो असो लावला कॉम्प्युटर पाठ किने लाईकचा एक्सिडेंट झाला तुमच्या काय पण लाईकचा आम्ही बियाले आणि गाती उडकी नाही आणि धरलो नाही का so this was like if these situations are real, also we say law should be like ek kuru jai, but what you will do in this kind of situation that when the accused is ready to full like yesterday, I don't know, like last week there was one case wherein in pavement one person who is not mentally disturbed person was roaming with knife and chopper, and like he was coming to assault his brother. So many localities were together, and then eventually there was some assault comes between them, and eventually dies. So offense was registered against the locality people for kind of committing murder. Okay. Now imagine this situation, the whole Panchanama and whole to be done. So but we are dealing with this issue in PNS. Yes, it is lawyer's paradise. To be very frank, I always tell my previous boss for 10 years you are settled. You don't have to worry. There will be lot of cases, so there is lot of interpretation of law and lot of things you have to argue in the court to say this is bad, this cannot be done. So these are all new aspects. Then once this investigation part is over, next comes is arrest. Arrest of the person. Arrest is defined now, or arrest, how the arrest to be done by any police officer has been prescribed in section 35. Now only one change in the old CRPC, it was under 41. Now it is 35 section. Only a departure from CRPC is that they have said that not to arrest any person where the offence is below 3 years and it is old age and infirm. So those persons will be not per se arrested. Wherever the offence is up to 7 years, then it is said that a notice has to be given, which is exactly like our old law. Not much change is there. But the main change which has happened in the law is that section 183, section 43. 43, handcuffing has been brought back. Now imagine handcuffing. Now there was a big argument earlier in Supreme Court, and Supreme Court said no, that handcuffing is not allowed in India because they cannot trust our police so much that they will misuse the handcuffing, and it is in violation of Article 21 of the Constitution. So it was done away with handcuffing for almost more than 30-40 years now. So that has come back, and they have said that now handcuffing can be used while arresting or taking you to the police. If you are involved in a murder, rape, dacoity, drug cases, arms act, terrorist activity, like where the punishment is like the life and death or about 10 years. So you can be handcuffed now, it's not illegal. So there will be definitely a protest and challenge to this provision, I believe, because it was settled law. Then comes is next, the controversial is remand. Once you are arrested, it is said that within 24 hours you have to be produced before the court, and court has to court is allowed to remand you for maximum police custody 15 days. That was the earlier law. So if you are taken to the court, court can give you 15 days totally or police custody, and then send you to judicial custody, that is Kolwali, and until and unless you get a bail. So that was straight 15 days, and there was continuous arguments on this in Supreme Court with respect to Sanjay Dutt's case, then Hiten Thakur, then there was Anupam Kulkarni. But recently what happened was one minister in Andhra Pradesh was arrested, some Balaji, and the moment he was arrested, it was under PMA, the moment he was arrested, that he got admitted in a hospital. So, and he stayed in a hospital for up to 15 days. And then he said that no, I cannot be taken back to the police custody for investigation. So I have to be sent to judicial lockup, and you cannot take my custody. So that part, it was challenged before the Supreme Court, and it is referred to the larger bench. I think so. In that context, the law had changed now. That 187, 187 section, which says that the police are allowed to take a staggered custody now. This police, if they arrest you today, they can say, they come to the magistrate and say, all right, give me 2 days police custody, and after 2 days, put you back in the judicial custody. Then come back again to the police and to a court and say, no, I want more 5 days or 6 days. So they can use this 15 days now. Well, whenever the offences are up to 7 years, then within first 40 days they can use. Whenever the offences are about 10 years, life and death, then they can use first 60 days to take your custody. So what is the effect of this? See, the earlier the law of practically magistrate, when they grant you bail, they always see one factor, whether you are required in a police custody or not. So if you are not required in police custody, mostly you will get a bail for any offence, mostly, except for the life and death. But once these provisions are there, every time police can come and say that no, I want this police custody. So your custody in the police or in judicial may prolong for either 40 days or 60 days. That could be new norm. Although the bail provision is there, it says that no, if they are asking for judicial custody, you can't, that factor cannot be considered. But problem is not that. Problem is this. Problem is, let's say 2 days police custody is taken, then you are sent to judicial, you file a bail, you get bail. Police come back and say that no, I have got new evidence. I have arrested Mr. another accused X. I have got new evidence, and that I want the custody of this man. So they have to go for cancellation of bail. So imagine the litigation which will start revolving around arrest, bail. So this is the new norm. I believe there will be a lot of challenge to this particular section. The next two things, which is more for the actually activists for their like whenever you see that there is corruption around and you want to file a complaint, you go to police, you file a complaint, police does not do anything, then that you follow a process of 173 to 176, wherein you say that no, all right, police has not taken the cognizance, I am going before the magistrate now to file a complaint. It is allowed. So you go to magistrate now. The new law is that magistrate will not directly take a cognizance of your complaint. Magistrate will say, you have filed a complaint, man. you go and bring a report from a superior officer against whom you file a complaint for bribery. Now can you imagine this? Who will give a report? Every senior will give a report to say that yes, that this man is corrupt. So this is the problem area which perhaps most of the activists will face. Not only a report, the change in law is also that 173 is one in section. (176) change is this person against whom you are making a complaint, he will be also called down to the court and say, all right, Baba, what do you have to say? Now, when you have called the accused, what accused will say? He will say, I am tried Getla. So, the matter may collapse there only, one, or you may have to file appeal, revision, and there will be more and more litigation. So, things which could have started faster, perhaps, will not start faster, but we will have one round of litigation, maybe up to Supreme Court and back, to start the actual complaint in this kind of a process. Same way, there was also another aspect in criminology, wherein whenever this complaint was got registered, you could have filed a private complaint before the magistrate. Police gave a complaint, now file a private complaint. In there also the change has come. We say that under 210 of PNSS, they say that no, magistrate cannot take cognizance now. So you call the accused. Prima facie, you hear the accused and you pass the order. Now what will happen there? Can magistrate come to conclusion directly that yes, there is a evidence against this man? That means you have curtailed one step of criminal charge in the whole process of the law. Because how the law goes, or the trial goes, first the complaint is filed, then accusers are called, then accused are called to explain the charge, then witnesses of prosecution come, the witnesses of defense come, final argument, and the order. This is the way by which the law or trial goes. Now, if you are called to start only, you may have the evidence, because accused may have the evidence, and the magistrate have to appreciate it was not there. Supreme Court and earlier all the judgments of Supreme Court said that no, accused has no right or no say in anything in criminal trial till the stage of defense evidence. So only when accused to come as defense evidence, he could produce some document. One way it may be beneficial to the accused, but for the activists or others it may be not so beneficial. So it has both ways. Let's see, since I don't point how it will really work, how it will be beneficial, we will not. Then what new has come again is this: in a trial, time limits are fixed. Means now after a charge sheet is filed, after charge sheet means once they collect the evidence against the accused, the charge sheet has to be filed in the court. Once the charge sheet is filed in the court, accused are called by issuing a summons. So that summons can be issued now by way of SMS, email, WhatsApp. All that is brought in. So you don't wait now that you will receive a summons by way of paper. So paper is done away with most of the laws. Once the summons is issued and the accused comes before the court, here a charge sheet has to be given to you. You can get a charge sheet down by a soft copy. No hard copy is required to be given. That is what we said. It is in addition to the hard copy, but a soft copy can be given to the accused. So accused cannot cry now saying that no, that I want a charge sheet. And it will happen. What will happen is mostly the charge sheet will be given a soft copy. Police will only take one copy. Now earlier police used to take 3-4 copies and used to give to the accused. Now what police will do? Police will file only one copy for the court. Rest of the copy will be sent on your phone, and they will tell you go and Xerox it. So if you want to defend yourself, then you spend your money. Because sometimes the charge sheet runs in the thousands of pages. Like we have cases like a PMLA cases, which runs in 5,000, 10,000. So you have to spend little from your pocket, perhaps you want a hard copy. That is what it is as for this new law. Then another change is that charge has to be explained within the 60 days of the first appearance. See, we are in Goa. I recently had a visit to Bombay for one matter. And in Bombay and all, they are not bothered. The charge sheet is fine. They will give you a date after 3 or 4 months. So, but now the new law says that no, after you appear in the court within first 60 days, you have to frame the charge and start the trial. There is a provision which says that trial has to be taken on day-to-day basis. But you know how it functions in the court. It never, see, all the courts are over. In MAPSA, we have 3 additional session judges for typing. But in 2 courts, the judges didn't have power, but we have learned today only the power is given to them. So all the cases to go to one judge. So humanly not possible for one judge to take so many cases. And these cases, basically when the witnesses come, one witness will take around 45 minutes, 1 hour per se. So it's practically not possible for one judge, another to have multiple judges to deal with the matter. Because the claim which was made why this law was brought by them was 2: a fair trial and a speedy trial. These are the 2 reasons for which the law is brought. Now, whether whatever these provisions are brought in by them will help trials to dispose of the cases in a speedy way or no, only time will tell us. But what I felt, what they have lost or what they have not changed, is this law. Maximum time in a criminal justice system goes in a trial. Sometimes the trial takes 2 years, sometimes the trial takes 5 years, sometimes the trial even takes 8 to 9 years to complete. Now, they could have done something to frame, although day to day is there, but practically not possible. But they also know. So, they could have done something which, by which they said that already. In particular case, if 10 witnesses are there, then you have to finish this case within 6 months. 20 witnesses, 1 year. 30 witnesses, 2 years. So at least the accused knows that my case will get over within that time. Even the victim, they will also know. Otherwise, everybody, whether it's a victim, whether it's an accused, they come to the hope. For them, going to court is an activity. Somebody told me that day that like one client is to come, is to call the lawyer, and she used to say that all right, like I'm going to come to my case today, and she used to pack her tiffin and all, and used to come to the court. So she used to sit in a court hall, and sometimes the court used to just say no, next date. So it's something like she has come prepared that something will happen in the court. And I think so litigants come to court with a hope that yes, something, whether it's victim or accused, that something will happen in the case. But always it does not happen. There are many times you just get a date and you have to go back home. So therefore, when you change the law, and the whole object of changing this law was that no, we want to dispose perhaps the cases faster. Today, still there are almost 5 crore cases pending in India. That is only in the judicial section, not in the executive section. Like Ambedkar, collector, those courts are different, another set. But so many cases, and with this COVID coming in, it has more cases have increased more with respect to that pending time. Now we are still dealing with those time cases. So unless until we have more courts, more judges, perhaps system will work faster in the criminal justice system. Another aspect which I felt which they could have changed was a plea bargaining, because plea bargaining works fantastic in abroad or in other countries. Like, and you know that was this opening of new courts in Belgium. and Supreme Court Judge Justice Pope was there, and he was delivering one lecture for the speedy justice system kind of thing. What steps can be taken and what can be done. So this plea bargaining, I raised this issue why plea bargaining is not successful in India. So he said there are two reasons. One is every accused who is accused in a case knows that he has a fair chance of acquittal. Fair chance. म्हणजे त्याला चडशे acquittal लागले कित्याक Indian cases are sobana. So if there are 20 witnesses and the trial starts in 2001, then by 2010 witnesses marta, so chances get acquittal chances get more. Or somebody disappears, somebody is out of station. So he said that is one of the reasons. So they know inside. Every accused knows that possible. So they always go in for trial. Whereas abroad the system is slightly different. He said that there is a timeline there where they say once we start a trial, within 1 month we are going to complete. And if there is some solid evidence, which accused also knows that by a knife, blood is there on the knife, which is the victim, and his blood also is there. So there is sufficient evidence to implicate him. So he is afraid that I may get a life sentence. So there he makes a choice. When the plea bargaining is given to him, offer is given to him, if you take plea bargaining, I will sentence you to 5 years. He takes that offer. So, but that does not happen in India because, and I had quite a relative answer. It's correct. Because sometimes we also see the case and we say, "Suttal, we are not to worry about this case." And Chinese आता 100 witness. This case सोपचित ना. Witness age. Somebody is 50, somebody is 70, 90. So this is what happens. Another point in this plea bargaining, what I feel, because he said also, he blamed lawyers also. He said lawyers that not advice because they want the trials to go on so they can earn. Correct. No problem. Correct. But what happens is, which we have seen, because many times we have advised people, especially foreigners, take this plea bargaining. Why do you want to take plea bargaining? They think if the plea bargaining is taken, plea bargaining means where you are saying that alright, sentence is 10 years, but a smaller sentence can be given and let me go. This is called plea bargaining, concept of plea bargaining. So if you say that I am the plea bargaining then मला job मेळचो ना, मला voting करपाक मेळचें ना, मला भायर वचपाक मेळचें ना. By condition जातले पळय रिपोर्ट सगळी उरतलो माझ्या नावार. So if they had changed this law, because you see the BNS, like they are altogether 378 sections are there in the new BNS. Most of the offences, I think most of like more than 200 offences up to 7 years, where you qualify for plea bargaining. So if a plea bargaining concept starts in India, people start taking plea bargaining, and they are told, all right, you will be perhaps only given a punishment of admonition, or you will be given only this probation of offenders, and this conviction will not be used for any other purpose. Means the conviction record, suppose the first time offense, this conviction record, so scrap करतलो म्हणून, so first actual record. Perhaps I feel many people will take this plea bargaining in India, and then it can be, if the plea bargain is taken, if the offence is under 5 crore cases will go down in one shot, like maybe one crore, because these are the cases pending. Saurabh Piyala, like some one of the case was there, like this, where a person was caught drunken driving, but no accident. So the like a test and they are children malo. So it's an offence under Motor Vehicle Act. So he comes before he pleads guilty. Judge gives him sentence of 5 days. Now he was working as a manager in some corporate. That conviction will be there on his name if he says, "Oh, I'm going inside." But then eventually that permission was challenged by him in the court, and then High Court said that why don't you take a rescue of probation of offenders like section 3 and 4 and do 341 something in PNS. He said under probation of offenders you act is used, then you can't be put inside the lockup. So they will give you something, perhaps community service, which is a new concept for in the new law. It was not there earlier, the community service, but community service is allowed for certain offences. So this can be used, my take. So with this, I will go to one more topic, which is the topic for the day, which was hierarchy of the courts in India. That is, and the powers and jurisdiction of the courts. Top is Supreme Court, then High Court, then Sessions Court, then the Judicial Magistrate First Class, Judicial Magistrate Second Class, then Executive Magistrate. This is the hierarchy. Everyone has different. Supreme Court, both civil, criminal, writ petitions or writ jurisdiction. High Court, same way, civil, criminal, and writ jurisdiction. Additional sessions and additional session judges. Now, session judge is a original criminal court where it can take a cognizance in special cases like a PMLA, NDPS cases. When a charge sheet is filed in a court, the court can take a cognizance. Same way, the magistrate court is also a criminal court wherein magistrate can take a cognizance of the case when a charge sheet is filed for them and then commit it to the higher. Also, they have some peculiar jurisdiction. Magistrate can only like punishment in India are of 5 types. One is death, second is life, then simple and rigorous imprisonment, fine, property forfeiture, and one more is this community service, which is introduced now. So these are the type of punishment every court can. Magistrate can give you this community service, forfeiture, fine, rigorous imprisonment, and like rigorous and simple imprisonment. Sessions court and additional sessions, they can give life and death sentence, but death sentence has to be confirmed by High Court. Because unless it is confirmed, it is not taken care of. Then next is with this sentencing, one of the new law, what is taken away or what is repealed or abolished is assistant session judges. This post is not there anymore. And one more court they have taken away or abolished is metropolitan magistrate. But it was more like in Hyderabad, Bombay, in metros, there was metropolitan magistrate, right? Shared a jurisdiction. So assistant session judges have done. Now what happens to the cases? The pending cases are there before the court, wherein the trials are going on. So what happens to those cases? Can the court say no? Your court is now. Sorry, case ka na or case openly. No. The High Court has to come with some notification and transfer these cases to the Sessions Court, or Sessions Court also has power to call for this. Till then, the assistant session judge will, till the last case is disposed of in India, the assistant sessions court will be there. Assistant sessions court will be there unless until the High Court does all that part. Another factor, one important which I missed in the investigation part was one this provision they have introduced, wherein they have claimed, this is very interesting, claim that if any accused is arrested now, especially let's take now the famous case which is going on, land scam. Okay. That person is arrested and police are saying no, we have attached various kinds of cars, high-end cars from her. Some money is attached, some gold is attached from her. Now this becomes a property. And the new law says a particular provision says 107, attachment, forfeiture and restoration of property, 107 of PNSS, which says that whatever property attached by the police has to make an application before the magistrate to freeze these properties. And once this property is freezed, the victims, whoever the victim is, they can come before the court and claim these properties. Now imagine this case, a new case, where this scam is there. And if nobody is claiming, eventually it will go to government. Now two cases, I will give an example, is land scam. If nobody claims all those cars, perhaps all those cars will go to government. How the car will be distributed? A BMW attached on someone, and like 10 lakhs is the scam. How that will be distributed? I don't know, but they said that district magistrate has to distribute. Yes. So how the gold is distributed? What happens to the claim if this is distributed already? And the person, the scammer gets acquitted. How can he reclaim that car back or money back? That is not there. It is open for interpretation, but there will be lot of litigation, lot of argument for this. Interesting one aspect which as a second case which can be used here is SIT. Now you are aware that SIT is something 80 property cases, fraudulent transaction has happened, and the SIT was formed to conduct investigation. They are claiming that yes, this sale deeds, everything is fake. By preparing a fake document, this sale deeds are done. Now accused will not come before the court and claim the property. So victims has to come to claim. So victims does not come, the entire property perhaps will be forfeited to government as per this. When victims come before the court, imagine a family which has around 20 people who's claiming. So can a criminal court decide the right of a civil jurisprudence? Is another big issue which will happen when they distribute the property or when the property is being distributed among the various legal age. But tomorrow this can be a racket. You file tomorrow a person can file a FIR, get the property freeze, come and say no, I am this, don't show much about the title and all, I am the victim of the property, I am possessor of property, give the property. And the court may pass order or the property may be handed over without going into the civil law. Because this is distribution of immovable property will be in a civil domain. Like certain laws, CPC, all that will follow, but this may happen, it may use. Another aspect which is trial, which an entire trial can be conducted today in absence of the accused. Earlier what is to happen? If one particular accused was not there in a trial, in a criminal trial, then the court used to keep the trial pending by issuing a warrant against him. But today, with this new provision introduced, it is said that no, the trial can proceed against him in his absence. Perhaps this has come after our famous people have gone abroad and they are enjoying their life there. Their properties are here. So these two provisions are interlinked, like attachment of property and trial in absence of the people who has gone abroad. So this is that provision is trial in absence of the accused is 356. Then accused has to come within, if the accused comes, he can claim, but accused has to come personally. So he will be arrested or whatever. So that procedure will follow. So that is with respect to the BNS. We have, how much time we have? 7 times. And just 5 minutes I will take more and I will finish with respect to see certain with respect to PNS, that is the old IPC. No, they have introduced certain new sections, around 28 to 30 new sections have come. Old sections are taken away, sections like which is taken away from PNS is sedition, attempt to commit suicide, unnatural offense, adultery. The new section which is brought in by them is like mischief, then mob lynching, hit and run. Hit and run is still pending, but hit and run with the punishment is 10 years. Then hiring children for committing offence is a new section. Then snatching, theft. So these are the new sections which is there introduced. One of the sections which I feel which will be misused is that section 69, which says that having sexual intercourse on false promise of marriage, employment, promotion, etc., or concealment of identity. Let's say we have seen in 25 years of practice a number of cases when the relationship goes bad, that lady sometimes comes and files a complaint. But the whole idea is that either you come back or you go to jail. This is the idea. And this will happen with this 69. But earlier, they should register offence of rape. Even if there was a relationship between two people, young adults, they always used to register the rape and 420 charges. So that they can register under 69 now. So new section which says that two adult people having a sexual intimacy between them, relationship goes sour, the lady goes and files a complaint, police can arrest. But this carries a offence, this carries a punishment up to 10 years. Imagine the situation, boyfriend and girlfriend in college. You know, this can be misused to an extent. I don't know how this, and so like the courts have to come to some conclusion that no, because it is very difficult at this point of time when an FIR is filed to know what is right and what is wrong. Whether indeed that promise was there and not. But everybody, when you are in college, everybody promises their girlfriend, I will marry you. You know, so it's simple. So imagine and how many people get married to their girlfriend. You know, I was talking to my friend I where sir came, he said, we are exchanging some girlfriend number, but is my classmate from college. So this section will be misused. But there is no much change in BNS. 90% of the BNS or the whole IPC remain the same. What they have done is that little bit interchange of sections. They have got all the offences of women and children in one chapter, then definitions in another chapter. So they have put kind of a sequence order, but that will create problems to the lawyers, not for general public. But we were used to for last 25 years. Those sections, especially that 420, 420, if like that 420 was there, perhaps that 420 will be viral in the landscape. But now it will be 318, because 318 can go viral for the landscape. With respect to the new PSA, there is no much change in PSA, but they widen the scope of definition of evidence and definition of document. These two scopes are widened, wherein they have brought in the electronic evidence into place. So today electronic evidence will be admissible. So lack of time, this 1 hour is very short time to deal with 3 laws because it's really vast. And so there's a lot to speak, but I think so I try to cover maximum the highlights of the not in details. So yes, we will conclude here and then we will take questions.
So now we will ask, keep the floor open to questions. Please put up your hands. Yes, you're on first.
Thank you.
Yes.
I was quite amused actually when I read 69. If you turn it another way around, then it'll be gender neutral. That being said, what would we deem in necessary to file a 156.3?
I covered that in the first topic only, 173. Now 156.3 has become 176 for 176, correct? So as I said earlier, after the complaint is filed, police does not do anything. You have to go to the SP, complaint, we does not do anything. Then you come to the court. So whole process is same. That you come to the court, file a complaint, got changes, you have to file a affidavit. Now, with a complaint, you have to file an affidavit. Earlier this was not there. But in the judgment of Dalita Kumari case, that Supreme Court scanned many provisions with respect to of this and how this was misused by many people. So Supreme Court said that Dalita Kumari that no, if you are coming by your 156.3 before the court, you file affidavit. So tomorrow you file a false affidavit, you can be charged for perjury. So that is the.
What if it's filed prior to 1st of July?
What is?
156.3 in the JLFC.
Then the old CRPC will follow. That is the section 531 of BNS. You will be, if you have already filed, then you will be covered under 531. But if you are, let's say for your case, so everything has happened earlier and investigation is not pending in your case now. Investigation is not pending. Nothing is pending. Perhaps you have to file under new law, BNS, because as I said, only 5 things are there, which is under by everyone. Investigate, pending, appeal, application, investigation, and trial. And there's one more. So trial. So if you are going to come within this area, then you have to come under new law.
You have a question? Number one? Then number two.
Thank you, sir. Going back to this question about 156/3, I believe you have to wait for 15 days to go before an SP, and then
So there's no time limit.
okay, I was told 15 days. The other question is, how much time do you have to file 156/3 in the court?
There's no time limit.
You can go 5 years.
Earlier also, see, in a specific criminal jurisprudence, there is no time limit. There's only one section, so there, where the court can take cognizance on it. But otherwise, there is no time limit. So imagine, in the rape cases, we have seen people come and say, I was raped at the age of 10 and she is 20, and you book a person with Children Act. This happens.
But I've been advised by a lawyer that you have 3 years, so it's not advising to file 156/3.
But I'm not sure about that. I don't think so. You can read 156.3 and you can read 176. Both the provisions does not have any time limit.
Okay, so perhaps they're misleading me. Perhaps the lawyers are misleading me.
Instead of that, you check the law. Google it.
Let's Google the law.
Sir, in case of assault, if victim is having only medical certificate, then that accused be punished. Judge can take action.
These are talking about trial, is after filing a charge sheet.
Yeah.
Now, if there is only medical certificate and no witness, how can court come to the conclusion that Mr. X has assaulted Mr. Y? You understand, no? If I am assaulted, I have to come to the witness box and I have to say that yes, I was assaulted by Mr. X. And this is my medical certificate. So both are required. If I don't come at all, and if there is only medical certificate before the court, then is it possible?
Medical certificate plus birth certificate plus alcohol certificate.
Fine. Certificates are evidence. See, we have something called oral evidence, documentary evidence. So what we are talking about is documentary evidence. Now, whether in a criminal justice system documentary evidence is sufficient to convict the accused in absence of a person coming before the court and saying that he was indeed assaulted. That certificate will show that yes, there is assault from Mr. So-and-so. But there is requirement of the evidence. So, we are talking about conviction, we are talking about appreciation of evidence. So, I feel magistrate will find it difficult to convict, and the defense is always will argue that we do not have evidence. Because let's say in your case a doctor, you will say the doctor will come, doctor will say that yes, so-and-so person has come before me and I am examining and this is medical evidence. But that person is not there. So that is all this, right? So it will be difficult, I feel, to convict a person only on a base of medical certificate.
Both were taken for medical. Both were taken. That is a victim.
Yes.
That is not enough.
No, victim has to go to witness box, no? To say that yes, I was assaulted. That's what I'm saying. So if that is there, yes, then you have very good, fair chance. All the other factors are there. Panchanama, then the other eyewitnesses is there. If there is circumstantial witnesses, if the your finger on your clothes, then that is attached or not. So the court will see all these factors, not just sole factor. So, sole factor usually taken into consideration in cases of motive or offensive in children.
Next question. The gentleman.
Supposing somebody makes a totally fictitious complaint to the police. Now, I suppose that the police would come to investigate. What should the person who is accused do in such a circumstance?
So very good question. As a project asked by most of the accused that this complaint is false. Now the complaint is false or not false. Who should decide first? Prima facie, the police will decide whether indeed some offence has taken place or not. If police believe, because the work of deciding this is given to police. The police believe that yes, there is some evidence which they claim that as per the complaint, there is evidence in this case. Then they will come to conclusion that yes, we believe that there is evidence and they will file a charge sheet against the person. And then they will put up for trial. You may prove yourself innocent at the trial and you may get benefit of doubt. But problem in Indian system is this. Our compensation laws are very weak. So many a times, like we are asked whether I will get compensation. I will give you an example. When in Supreme Court, Supreme Court said, a person who is inside for almost 10 years, after 10 years he has an acquittal, he comes to Supreme Court for compensation. Supreme Court does not come in compensation. Because Supreme Court something says that you are given a benefit of doubt. Because you see, most of the judgment in judiciary, you are given a benefit of doubt. If they do not give benefit of doubt, the government coffers will collapse. Because 70% of the cases goes for acquittal. So 70% people can come for compensation in India. This is what it is.
There is a question about digital evidence. With the acceptance of digital evidence by the new criminal courts, are there any procedures set in place to scrutinize the digital evidence for possible data tampering? For example, deepfake videos used as camera footage, Photoshop images, etc.
I do not know whether our police are qualified. Because for this, we require this computer engineers, science graduates. And as I think you have them, you will not. But as a defense, I can tell you. For example, when you take photograph, you have a camera. Okay? A photograph, when you click, it will create a file. Let's say file number 101, 102, 103. So one photograph will have one file. The second photograph will have second file 102. Third photograph will have. So it is stored in a computer. If you check, you go to setting and check, this sequence will be there. 101, 102, 103, 104. Now, if you check and 103 is missing, that means you know that somebody has mutated that or somebody has changed that. So it depends on person to person. So therefore, as I said earlier, they are wanting the forensic people at the investigation level. So if they involve the computer engineers, perhaps yes, that they will be able to trace The lawyers also have to be smart to detect and understand that yes, there is the mutation in the deep way is extremely difficult, which everybody knows. But yes, the settings you will get because it's a separately created file.
One question I want to ask you is, from your lecture you said it's become almost impossible to prosecute politicians or accept corruption.
Yes, because of that particular section 176 read with 210. Now 210 says that the magistrate cannot take up cognizance without a report of a superior officer or giving an opportunity for him to come before the court and make submission. Now which accused will come and say I have done it, or which superior officer will give that report saying that yes, this man is corrupt and he has done corruption during his duty.
But there wasn't that done earlier by 197?
No, this was not there. This was
197 prior to the government.
no. Now the accused is given a chance to come before the court under that 210 and superior's report. See, no, I'm not talking about sanction was 197. Sanction was required, it was also required. But here, they have given in addition to sanction, this additional provisions about it, wherein a report is called from superior.
On the same subject,
Yes.
if the senior doesn't give a section
Yes.
in 90 days, then it is deemed that the person can go ahead.
You have to go to lawyer for this. Yes,
You can.
giving this. That is about that has come in sanction. That has not come in report. If you read sanction, yes, it will, in 90 days sanction is not given, that will deemed to be given. But nothing is there for a report of superior. That what you check, 210 you check 176. Yeah, 197, yes, you are right. That is what.
What about minister? Who is the superior of the minister? Suppose I want to file a case, criminal complaint against Mr. Rani.
There is lot of litigation on this. So it will take a lot of time to the Supreme Court decide this kind of issues. I think. Yes.
Can you explain the
That's what all the accused wait for, right?
Yeah.
So can you explain this concept of benefit of doubt more clearly in terms of the legal implication? The second question is, you say that so many acquittals have given up. Does it serve the purpose of justice?
No. No, and therefore, to see the law, which is, I will answer the second question. To see the law today, see the earlier focus was more on accused. Accused should not be handcuffed, accused should not be kept in police custody. So, all the focus, like Article 21, so law was thought only about accused and accused. But now, this is a very victim-centric approach by the legislature. Victim's interest is taken into consideration. So victim is brought in every stage. Now, even after filing a complaint, within 90 days, the police has to intimate the victim what the status of this case. So victim can come, the definition of victim is expanded, victim can come at the stage of pain. So it is a victim-centric approach, which is good enough. Then going to next benefit of the concept of benefit of doubt. Concept benefit of doubt means that the court says that yes, there is no sufficient evidence to convict you in a criminal case. For example, the Asgam case is there. If the Asgam case only evidence was the cameras which settled, then all the witnesses goes hostile. Then the time we are settled, they are not bothered. So camera is the last so in that case, when they open the camera, they find there is no recording in that. Because the DVR is not attached. So you get a benefit of doubt. It's simple as that. And like basically when the evidence is not sufficient to prove your charges, that is when you get a benefit of doubt.
Hello, sir.
Yes,
I just want to ask a question. Generally, when the police arrest you, do you have the right to remain silent? And what is advisable? What would you advise a person if they actually committed something and the police are interrogating them? Do they have the right to say that I'm not going to speak? I'm going to my word? Is that something that you would advise?
You are watching a lot of Netflix.
Yes.
Yes, but but yes, accused has right to remain silent, not only at the investigation stage, but total trial also. Accused can sit. What we deal with criminal justice system works on a concept innocent till proven guilty. So police has to prove the offense against you. You don't have to do anything. You don't have to open your mouth. You can sit entire trial without opening your mouth. And still the police has to prove. And therefore the change is this. When they say that forensic evidence, the videography, so all these are good concept. So which will happen tomorrow. If like you said, witness does not come to the court, but a video is brought to the court showing the magistrate or the court can appreciate it differently. That's also evidence of today. That can happen now. So remaining silent, yes. But you will speak immediately when you are arrested. That's sharp inside.
So, in a scenario where you expect threat from someone, okay, and you know that there is an hazard and it's not a serious hazard, the other person is going to instruct you, right? So, what is your advice? Like, what is the best thing to do in a case where there is a fight? Put it back, or you just take it from him?
With respect to see, every person is allowed to defend himself and his property. His rights are there for there in IPC, there in DNS also. So, tomorrow if you are with your wife and somebody comes and does something, you have to react and then you have to claim that I have done a private defense. But you cannot use an excessive force. So that is the difference. Excessive force is a different definition where somebody has come with a chopper to hit you. And what force you will use and what you will consider excessive force to you take another bar and hit him on his head. But whether it will be excessive or not will be all interpretation by the courts. But yes, private you can definitely protect yourself in the private defense. Because you are covered under defense. These are the exceptions to the offences.
And another question regarding the electronic evidence. So, if you receive a threat call, is it legal in India to record the phone call?
Recording is not legal per se. Recording. Whether you can record and use it, or is it not?
When you are the participant and the other person on the call is aware that you are recording the call. So still, because I don't understand the logic, like in many cases you can do video recording, right?
Yeah.
Go to a government office and if the officer does not treat you well, you can do a video recording. Because lots of videos are posted on Facebook and social media. So if video recording is allowed, and if you get a call, can you put the phone on speaker and record it, do a video recording from the other phone?
So there is no law to prohibit you. Neither the new law says that you can't do this. So unless it is will go in a domain of this privacy, law privacy, whether you are interfering with the privacy by privacy or not, in a public place, private place. So this will be all to the interpretation. But yes, this is going to come and somebody will argue soon that whether it's allowed or not allowed.
What is the procedure if the person files a complaint that you have done an audio recording? So what is the procedure? Do you need to surrender your phone to the police station and it lies there for many months?
There should be some offense, but now in recording or whatever, or where is the offense? So unless there is an offense, police says we want to investigate, then the attachment and all will come. Right? No.
But in case if there is a threat call,
Yeah. Threat call will be offense, no?
Yeah, it is
Yeah.
an offense.
Yeah.
So it's okay to record.
That in short, we are saying I'm collecting the evidence. If you ask me today, in today's term, and with this new laws, I feel that will be evidence. Simple as that. Because they have changed the definition of evidence, they have changed the definition of document. And both they have got electronic, this, both electronic is used. So electronic is this. So yes, as of today, we can definitely argue that this is the evidence. And therefore, I agree. So nothing against the law of privacy.
So invest in a smartphone.
Right.
Yes. Any other question, please? Yes. Yeah.
Yes, sir. So when the cops are taking liberty to do a video recording, and the quality of the videos or the mobiles which they are recording, that does not have the quality. A private person also does the recording, and he has a better recording than the cops. Of course, for once the system is incorporated, the system of recording, which one will win?
Really, whatever is the evidence will prevail.
Yes.
If a better
So
quality.
by default,
The law does not say the quality of videos. Law only says the evidentiary value of that video. So if there is a, like for example, I say somebody is putting knife into someone and that video is there. If video is good, not good, but not quality.
yes.
Both the videos will be admissible. No?
By default, cops do not do a proper recording. Their instruments are faulty. They just find a loophole for the evidence to fail. You see?
We are saying that they are doing on purposely for the evidence to fail. You can bring the evidence from the court. You are allowed. And you can also ask, and you can give a copy to the courts. You have to make application, give it to them, make a record that I have given. You will have a better quality. Also produce it in a court.
It is also advisable, on the other hand, that you do simultaneous recordings with the cops, because
Forbid Raju.
Yes. Yeah. See, there are not many criminals in this group. That's why I said that they're asking a lot of questions. They're all decent folk here. They're not that very much.
But that was very unique question.
Yes.
I never heard that quality.
Yes. One last question.
I would like asking Kogi.
Sir.
Sir, तुम्ही आता सांगल्या की नॉवेलचा भाव वाढला. तेतून खूपशे सिरियस केसेस जातात. तर सुप्रीम कोर्ट आणि हायकोर्ट स्वतः जाऊन हे गाईडलाईन घालून काढणार. फॉर एक्झाम्पल तुम्ही म्हटलं की कोणाची संपत्ती जप्त करपाच्या क्लेम इट. फॉर दिस पर्पज कॅन हायकोर्ट अँड सुप्रीम कोर्ट make a suitable publication and give guidelines regarding this?
I think all these laws were challenged and withdrawn by some of the lawyers. They have to govern now, but withdrawn fell after that. Okay, that's one thing. But yes, see, law will never be settled immediately. Now, what we are dealing with, like CRPC or Urban said, 1860, that's why I said it's a lawyer's paradise. There's a lot of things for the lawyers to argue, interpret, and settle in coming years. So this will happen definitely in next 2 years. Agree. Yeah.
I think we should all remember that these laws, who are they brought forth by? Politicians. More than half the members of parliament are criminals. They are going to bring in a law, they are going to protect their interests first. Please remember that. It's not going to be they are going to worry about this. At least half of it. Look at the Goa Assembly, 30 out of 40 people are real estate and contractors by profession. So they are going to oppose any change in the town country planning laws. They are very happy with many of these changes. They are very willingly there to pass them. composition of the legislators has changed so badly now. We may not get many great things coming out from what they have only explained today in terms of these two criminal codes and the evidence side. There are, I mean, the mastermind is Amit Shah, no? Was himself accused of murder against Justice Boya and something else.
He's the biggest thief.
So I'm saying, we have these people framing laws, criminal laws, we don't expect wisdom of God or Ram or anybody in what is happening. Anyway, that's enough for this evening. I hope there are no other questions. I'd like to present you and thank you. On Friday we have Justice Gautam Fidel coming from Bombay. Please note, former Justice so always we have to be on message. Vice President. No coming in at the end. And there are a lot of extra people coming or asked to come to that also. Their lecture. So we may have a few more extra people. So